While today's the day that Illinois State Police are holding a public hearing about the state's gun ban registry, we'll definitely touch on that in a moment. You've got the latest in litigation against Illinois' gun ban in the federal courts that we've got to tackle. Of course, we've still got the Seventh Circuit U.S. Court of Appeals handling an appeal on the Second Amendment issues that has multiple plaintiff groups from the Southern District and the Northern District of Illinois suing state and local governments over gun and magazine bans. And that's still pending in the Seventh Circuit. But you've got a couple of cases down in the Southern District where the state's having to respond. One about Thomas Magg bringing the question of the law being too vague to enforce, unconstitutionally vague. Another one from the Federal Firearms Licensees of Illinois looking to amend their initial complaint to try to block the gun registry that opened up on October 1st. And we've got movement in that. With the latest here, the state had to respond by November 1st, which was yesterday. So in the Southern District of Federal Illinois Court, you've got the state responding. It's a 3-page response. Let's just go ahead and delve into it. It says the plaintiffs and Federal Firearms Licensees of Illinois v. Pritzker, one of the partially consolidated actions captioned above, moved for leave to file an amended complaint with additional claims on October 25th. On October 26th, the court initially offered a defendants in FFL action, Governor J.B. Pritzker, Kwame Raoul, the Attorney General, and the Director of the Illinois State Police, Brendan Kelly, to respond to a motion to leave by November 6th. The next day, and we covered this on the show, the court moved the deadline for now November 1st. In accordance with the court's modified deadline, the state defendants now provide this response to the motion for leave. The state defendants believe that the allegations claimed in the FFL plaintiffs seek to add through their amended complaint are meritless, the state says, making amendment futile under Rule 15. It cites a court case and various precedent. Goes on to say, nonetheless, since learning of the FFL plaintiffs' intent to amend their complaint and seek immediate injunctive relief based on the pleading, the state defendants have been engaged in discussions with counsel for the FFL plaintiffs regarding the motion to leave and their forthcoming preliminary injunction motion to streamline proceedings for the parties in the court. Through these discussions, the state defendants have endeavored to reach an agreed-upon schedule that would be enabling for the parties to adequately brief the FFL plaintiffs' second preliminary injunction motion prior to January 1st, 2024, the statutory deadline for filing endorsement affidavits under the Protect Illinois Communities Act that FFL plaintiffs now seek to challenge. Well, I think that the challenge has always been about the registry and the law as a whole. It just seemed that with so many different plaintiffs groups, with different arguments, the agreement was to get it quickly taken care of, to consolidate cases in the Southern District, to take the Northern District cases, consolidate those into the Seventh Circuit, hear it on Second Amendment grounds. That way it can be expedited. But it's not being expedited. You've got the Seventh Circuit that's still holding on to that case, and it's been since June 26th when they heard the case in the Seventh Circuit Court of Appeals. And here we are, November 2nd, still no outcome. So obviously there's an impetus on people saying that they're being harmed because their constitutional rights infringed upon by not being able to purchase semi-automatic firearms. And then now, less than 2 months, they could face felony charges possibly if they, have 1 or 2 firearms that aren't registered by January 1st of 2024. So interesting to see that, here we got. Is this a way to try to delay things? I don't know. Let's go back a little bit here to the state's filing in response, only a 3-page filing in response to the FFL of Illinois. They go on to say the statutory deadline for filing endorsement affidavits under the Protect Illinois Communities Act, the FFL plaintiffs now seek to challenge January 1st. Consistent with these objections, the state defendants have agreed not to oppose the motion for leave under Rule 15 while reserving their right to challenge the sufficiency of the proposed amended complaint under Rule 12 based on the FFL plaintiffs' agreements. That's the following subject of the court's approval. The FFL plaintiffs agree the state defendants may have 90 days from the court's granting of the motion for leave to answer or otherwise plead to FFL plaintiffs' amended complaint. And the FFL plaintiffs agreed that they do not object to the state defendants having up to including December 1st of 2023 to respond for the forthcoming second preliminary injunction motion, which the FFL plaintiffs agree to file no later than November 3rd, 2023. So tomorrow we'll definitely be looking for and we'll review on Monday the latest filing from the FFL of Illinois on this particular case. But it looks like we've got more of a definitive timeline here, especially before January 1st rolls around. So again, you've got the state defendants here saying that they are agreeing to have these timelines. Plaintiffs agreed to do not object to the state defendants having up until December 1st to respond to what the FFL plaintiffs are going to file in just tomorrow. So based on the term agreed upon by counsel, the state defendants do not oppose the motion for leave and respectfully request the court enter a scheduling order consistent with these proposed items. The state defendants note that they have agreed to this briefing schedule proposed above based on the current status of these partially consolidated actions. Should any plaintiff in these partially consolidated actions seek leave to amend, file a preliminary injunction motion, or seek judgment on any claim between now and January 1st, the state defendants reserve all rights to seek additional time to respond. So this is going to be interesting, a balancing act of sorts, right? Because you still have those pending actions that Thomas Mag brought before the FFL of Illinois brought this proposed amended complaint. So how is all of that going to work with the action still remaining in the Southern District of Illinois while the Seventh Circuit still dealing with that Second Amendment question? It's a lot there, but that's the latest. So we've got some other things that are going to be popping off throughout the next couple of days here that we'll be highlighting each and every weekday morning. So appreciate everybody tuning in and stay tuned. Plenty more to get to here with Bishop on Air. I'm Greg Bishop. Thanks for hanging out. Follow me anywhere. Just search Bishop on Air. You can find me on Facebook, Twitter, YouTube. Just search Bishop on Air, and that's how we can make things happen and connect. So stay tuned. Much more coming up here with Bishop on Air.